clarify that I am audible. Good day, everyone. Can you hear me? Good day, everyone. I would like to welcome you to the second annual Lex Lata panel session on constitutional law. We are very excited to have all our attendees and guests here today. And I would like to say a very big thank you to all our attendees and especially to our panelists who have taken out of their time to come and educate us on the concept of a constitution. My name is Chidera Okoro, and I will be the moderator for today's panel session, which is titled The Concept of a Constitution. We have two brilliant panelists here today with us, and they are the constitutional law interns of the Lex Lata Center. And our first panelist is Olasukomi Awofadeju, and our second panelist is Itohan Eworo. If we can just give them a very big round of applause, either using your emojis or just in the chat box. So today's panel session, like I stated earlier, is focused on the concept of a constitution. And today we will be discussing several things such as the concept of a constitution, the different methods and of constitutional interpretation, as well as the different kinds of constitution. Before we begin, I would like to invite our panelists to turn on their camera just so that our audience can see them and even more engage with them. It's wonderful to see you, Mr. Awofadeju. Is our second panelist here, Ms. Itohan. So for all our attendees, we would like you to note that you can leave if you have any additional questions, apart from the panel questions that will be asked here today, you can either leave them in the chat box or you can wait till the end of the session and then raise up your hand and ask those questions. I can see our second panelist is here, Ms. Itohani Eworo. Can you please turn on your camera so our audience can engage with you? It's lovely to see you, Ms. Itohan.
Thank you, ma'am. Good evening.
Good evening. So we at Lex Lata are especially proud of our constitutional law interns because they have, for the past few months, been properly learning and understanding the concept of the Constitution, and they will eventually release a research paper on that very concept. So we are very excited to hear thus far what they have learned and to receive enlightenment for them on what a constitution is. So a majority of us are aware that a constitution is the bedrock of governance and of guidance for a majority of countries in the world. Therefore, it's essential for every single member of the Lex Lata Center, as well as every single person in the world, to truly understand not only what a constitution is, but the extent and the types of constitutions. So we would like to invite our panelists to tell us in 2 or 3 lines what their understanding of a constitution is. I would like to first invite Ms. Itohan to tell us her understanding of a constitution.
Okay, thank you very much for the question. So I think a comprehensive definition of a constitution was actually captured by the executive director of the Lex Lata Center, Dr. Kunuji. That definition defines the Constitution as a political legal document which sets out, it articulates the aspirations of a political community. It sets out and it normativizes the the goals and wishes of this community. But to break that down into, I guess, more understandable lingo, a constitution can be understood in regards to its nature and its function. So at its core, it is a political and a legal document. Political because it is it basically sets up a state, right? At its core, it's the basic charter of a state's identity. And then legal because it is then setting out the rules by which that state is supposed to be governed, how the people are supposed to be governed, the laws that they are bound to, and the obligations as well that they are to carry out. So that is my understanding of the Constitution. You're muted. I don't know if you are aware.
Thank you so much for that clarity. I will now direct the same question to Mr. Awofadeju. What is your understanding of a constitution?
Thank you for the question. Okay, so to answer the question of what my understanding of the concept of the Constitution is, the Constitution itself has various definitions. Does not really have a straightforward definition, but definitions that I can provide for that actually encapsulate the meaning of what a Constitution is includes the fact that a Constitution is a set of fundamental principles, laws, rules, and regulations that actually governs, protect the fundamental rights of citizens within a country, and also it provides for governmental powers and also its limitations. The Constitution is a political legal articulation of the interest, what the citizens of a country want, also providing for the system, the legal system, and also the political system whereby administration can be carried out within a state. It also provides for the economic framework of the state. For instance, Section 82, Section 162 of the Nigerian Constitution provides for how the revenue can be distributed among the tiers of government in Nigeria. So the Constitution provides for the economic frameworks, the social life of citizens, which can also be seen in Chapter 2 of the Nigerian Constitution, 1999 as amended. These amendments are actually what the Constitution is able to do, and my own understanding of the concept of Constitution.
Thank you so much, Mr. Awofadeju. So I noted that both of the panelists in your definition of a constitution, you both took special care to state that it represents the political and legal identity of a country. Mr. Awofadeju, you also went further to state that it could also show the social and economic identity of a state. So I would like to ask that can a constitution also show the moral and the cultural identity of a state? For example, a country like Nigeria that has several political groups and ethnicities, can the constitution be a document that goes further to show the moral and the cultural identity of the people within that state? And that question is directed to Mr. Awofadeju.
Yes, thank you. A constitution, regarding to the specific example of Nigeria's own, can actually shows and it provides and it can show the moral identity of persons. For instance, under Chapter 2, which provides for fundamental objectives and directives of the state policy, Nigerian Constitution, we're able to see social rights, cultural rights of citizens that are being provided for in the Constitution, even though initially these rights were not actually justiciable. Through constitutional amendment, through the interpretation of the judiciary, we're able to see that persons, cultures within the society actually have a right to what? A right to exercise whatever they feel is right within the context of the constitution and its legality itself. So we're able to see the constitution providing for this is your culture, this is another person's culture. As long as there's no infringement on any fundamental rights between each different cultures, different persons within the society, we all live amicably in law and order. The Constitution provides for this, and as I've cited earlier, Chapter 2 of the Nigerian Constitution, 1999, as amended, which provides for the social rights, the economic rights, and most especially what this question refers to, the cultural beliefs of each person.
Thank you so much, Mr. Awofadeju. So, Ms. Itohan, assuming that you agree with Mr. Awofadeju that the Constitution can in fact show the cultural identity of a people, just to clarify, Ms. Itohan, can you hear me? Fantastic. So what happens in a situation in which that culture or that political identity is not the same. There are several groups and they disagree with what the political culture of a country is. In that particular situation, what can the Constitution do? Should the Constitution create a shared identity for all those people, or must it reflect what the society actually is? Mr. Tohan, you are unfortunately muted.
Oh, can you hear me? I'm so sorry.
Yes, we can.
Okay. So it's interesting because the Constitution can be understood in from so many different, angles or subtopics. And one of those angles, or one of those groupings or headings that the Constitution can be understood is its general form or its general function. So it can either be a procedural constitution or a prescriptive constitution. The two are not mutually exclusive. So for a procedural constitution, it sets out more of laws, regulations, more the legal connotations that a state is bound to, limitation of powers of government, separation of powers, all of those things. But a prescriptive constitution would lean more to creating that shared identity, shared, enlist the morals, the values, the culture that it's basically creating a state's identity. So like I previously mentioned, it's not mutually exclusive. It doesn't have to be either a procedural or a prescriptive constitution. It's usually a mix of the two. Though to group it, you would look for which is more procedural or which is more prescriptive, right? But it is recommended for a constitution to encapsulate both in an equal balance. So for sure, a constitution should create a shared identity, right? And in a country like Nigeria, for instance, we do have what is called the federal character principle, right? That tries to make accommodation for all the different cultures, groups, beliefs that are present in our nation. So yes, a constitution definitely should definitely aim to do that.
So if I understand you correctly, a constitution is a versatile enough document that it can either create a shared identity or show the society as it is, depending on the kind of constitution that it is?
Yes.
Thank you very much. So just in line with that question, so what if it is the kind of constitution that does not, it shows society as it is, and in doing so, it does not in fact represent the wishes of the majority of the population? In that situation, if the constitution does not reflect the wishes of the general population, what happens in that instance? Should that constitution still be considered a valid constitution, considering the main duty of a constitution is to reflect the identity of the people?
Okay, thank you for the question. So there's some different arguments as to what a grand norm is, or the grand norm is in a society or in a state. Some would say that the constitution itself is the grand norm. I think proponents of that are the philosopher Hans Kelsen, the popular philosopher Hans Kelsen. However, we have come to understand that the constitution, since it is supposed to reflect the best wishes, the interests of the state, it is supposed to find its validity and its legitimacy in the people, right? So the people, in a sense, are the grand norm because it is their interests, it is their values, their morals that are being reflected in the constitution, right? So a constitution that is that veers away from that completely can't even be described as a democratic constitution. It can't be described as one that is legitimate because legitimacy stems from the people. I don't know if that answers your question.
It does. Thank you so much. So just to clarify for the audience, if the constitution does not reflect the identity of the people, the general identity, the majority identity, then it is not a democratic constitution.
Exactly.
Just in line with that, Mr. Awofadeju, do you agree with what Ms. Itohan has stated? She stated that, as a matter of fact, the grand norm are the people rather than the constitution itself, yes?
Yes, I do agree, but I just want to add something in. The legality of such a constitution, if the constitution itself is still the recognized constitution, it has not been altered, it has not been changed, it has not been probably amended, the constitution still remains legally still remains the constitution that is law binding. But when we now talk about in the political sense of it, societal sense of it, in terms of social contracts between the governed and those that are governed, as stated by Thomas Hobbes himself, we'll be able to say that such constitution is not actually valid anymore. So that's just what I want to add.
Yes. So Ms. Itohan actually mentioned a very, very unique concept. She said, if the people are not reflected in the constitution, then it is not a democratic constitution. In line with that, Ms. Awufadeju, do you believe there is such a concept as an undemocratic constitution? Do you believe that some certain states that do not practice democracies can still have valid constitutions?
The constitution itself is a reflection of the people's interest. So the major reason why we're having a constitution is to surrender our own personal rights as citizens of a country to the constitution. So whatever is within our ideals, whatever is within our own interest, our own wants, desires, we are able to see it reflecting in the constitution. So the non-reflection of our own ideals, our personal beliefs as persons, citizens, members of a society, of a state, an independent sovereign state, means that the constitution itself does not actually reflect. Now, if such a constitution exists, that means it does not have the legitimacy and the acceptance of the persons within the state. It is either that it is being enforced, and such a constitution cannot be tagged as being democratic.
Okay. So Ms. Itohan, are you aware that when the country goes into military regime, or when the military take over the country, certain parts of the constitution are typically frozen?
Yes.
So in that circumstance, are the parts of the constitution that are not frozen, that do not necessarily reflect the wishes of the people, does it still function as a valid constitution?
If you could rephrase your question, so
yes, of course.
You're asking, please.
That kind of constitution that has been molded to match the needs of the military government or the dictatorial government rather than the people in that instance, does it still function as a valid constitution?
In the context of a state of emergency or generally?
Generally.
Okay. Generally, no. I think what we have said before, what Alabi had said before, would be the same reiteration, that if it is, generally speaking, if there is a if there's a constitution that has been made that derogates the interests, the wishes of the people, then it can be valid, especially if it's one that is a democratic society, and maybe the military government came and seized power. A military government itself is not even a democratically elected government. It's not democratically elected, so anything that they do would not be democratic as a matter of consequence. So no, it would not be valid.
Okay. Well, that once again takes me to my previous question. Does that mean that a constitution cannot function in an undemocratic environment? In a dictatorial government, a constitution cannot function?
Oh no, it can function, because I think in its nature, it is a binding document. A constitution sets out, the laws by which people are bound to. So there's the power the constitution has over a state, over the people in the state, that you are bound to follow what is in it, what it dictates, right? So even though it wasn't democratic, it won't cease from being what it is, in the sense that it obliges you to follow what it says, right? Except in the case of the revolution, where the people would then say, this is not what we want, and so we are going to revolt, and we want it to be the way that we want it to be. But in the absence of that, fundamentally, a constitution compels you to be bound to what is in its provisions. So it would still function, because that's one of its functions.
Okay, thank you so much, Ms. Itohan. This will now bring us to the conclusion of our first part on the general understanding of a constitution. We will now move on to the constitution, to concepts in constitutional interpretation. And I would ask both panelists to please let us know what they understand by the concept of a living constitution. And I would ask Mr. Wofadeju to let us know his understanding first.
All right, thank you for the question. My understanding of the concept of living constitution is reflect on the ideals that whatever is going to be our constitution, or what is the constitution of a state, a sovereign state, an independent state, whatever is to be the constitution has to reflect the existing ideals, the current realities, social happenings within the society. So the living constitution itself, extracting the word living from the word constitution, reflecting that it is what is happening right now. It is what is existing, that which is occurring within the society. For instance, we did not have the existence of AI, data privacy, data protection, let's say 3, 4 decades ago. But right now, the interpretation of the Constitution itself has been expanded through judicial interpretation, amendment to actually occupy and to be able to address this AI, data privacy, data protection, among many others. So the idea of a living of a living constitution reflects on the fact that it encompasses societal happening currently, societal wants, demands, desires. Thank you.
Thank you so much, Mr. Awofadeju. The same question is directed to you, Ms. Itohan. What do you understand by living constitution?
All right, thank you. So a living constitution is basically one that is a progressive constitution, is one that follows the evolution of society in the sense of what is the current state of society. It is one that is flexible. It is one that evolves over time. It is not static or anachronistic. It follows the changes in society, right? So it's dynamic in nature and it evolves over time to address contemporary social needs or changes. So that is what a living constitution is.
Thank you so much, Ms. Itohan. So just in line with Mr. Awofadeju's previous statement on what a living constitution is, how can you distinguish the concept of a living constitution from the concept of originalism?
Okay.
All right.
So is that directed at me or at Mr. Alabi?
It's directed to Mr. Alabi, please.
Okay, thank you.
The concept of originalism versus the concept of living constitution itself, understanding that both of them, though they are different, they are also interrelated. Originalism itself stands for, we stand with that which has been made already. There's not going to be changes to it. There won't be alterations to it. For instance, if a law is to be made in 1949, before pre-independence of Nigeria, of Nigerian constitution, such a law, if it continues to exist like that, no amendments, no changes, and it is not removed from the constitution up to 2026, which we are in. Originalism is a principle, is a constitutional concept that is being applied there. That is based on what those that enact, the legislatures who enacted the law itself back then, what they had in mind, each and every word is still being retained, and the principle to that concept itself, to that section of the Constitution, has not been changed. The interpretation has been dormant. There has not been any flexibility or any amendment to it. That is what originalism itself means. This goes against that of, this is totally different from the Constitution having been a living constitution. A living constitution is able to provide for societal needs as it comes. So when a societal need is actually demanded, we are able to provide for it. An instance would be that of the United Kingdom unwritten constitution. For instance, in Britain now, there is no written constitution itself, but they have conventions, customs that they follow. So there is parliamentary supremacy. The parliamentary supremacy itself brings us to the idea of a living constitution. The parliament gets their own power from being within the parliament itself. So the persons within the society, when they demand a change, they are able to go to their representatives in the parliament, and a change is easily done. That is, changes within the society in the concept of a living constitution, being able to adapt and its flexibility. Thank you.
Thank you. So, Ms. Itohan, the next question is directed to you. So, Mr. Awofadeju has stated that living clauses are better because, people, let's say, using the UK's example, that people can easily approach their parliament that was democratically elected by them to have them choose, to have them make certain laws that match their new and improved identities rather than focusing on old laws that have since been outdated. So, do you believe, considering the fact that in most countries, as a matter of fact, the constitution provisions and other law provisions are actually amended more by the judicial system than the legislature. But the judicial judges themselves have not been chosen by the people. They're usually chosen by the government themselves. So, do you believe that allowing for a living constitution system where the laws can be changed by judges when they have not been, in fact, been chosen by the people? Do you believe that any such amendment can actually reflect the people's will? Do you believe that is in fact democratic?
Okay, thank you for that question. So this is actually a long-standing argument in the terms of constitutional law and constitutional interpretation, and there is still no general consensus as to whether it is right or wrong, as everything with law it is very nuanced, not very black and white, right? But I would say that with the living constitution, it is not, what is happening is not necessarily a formal amendment of the constitution. It is something called judicial activism, meaning it's a judge's own proactiveness to interpret the constitution in a more modern light. It is not taken away from it's not an arbitrary derogation of the core principles of the constitution, but it's more in the sense of the applicability, how the law is applied in that sense, right? And judges are given the power, to do that. That's the function of the judiciary, right? That they interpret the law in a sense. They're called the guardians of the constitution because they go from, because they do not make the laws, but so they pivot from that to interpreting what this law should be, right? So I understand that there is the argument of a judge, but the judge is not making the law, right? There is a sense in which it can be seen that judges are making laws, but it is their duty to interpret it. And I understand the argument of saying, but then the judge is pivoting to making the law. But that's why we have things like precedents, right? Because it is how the judge then interprets the law that in further cases it may be relied on. So that is in essence the role of the judge. In regards to whether it is democratic or not, I wouldn't outrightly say it was democratic or undemocratic. I would also say maybe to consider that those who, in an indirect sense, to consider that the people who appoint the judges were at least elected by the people, right? So in a sense, you are entrusting them with the power to select judges who would interpret the law properly. So I hope that answers the question of whether it's democratic or not, because I know that was the core of the question. I'm so sorry, you're muted, ma'am.
My apologies. So, Mr. Awofadeju, Ms. Itohan has stated that that judicial decisions do not, in fact, they do not make a law, just giving their own interpretation on what the law is. But in common law countries, which judicial precedents do, in fact, form part of their legal system and can, in fact, be considered by laws, can you state that any decision given by a judge that goes against the provisions of the Constitution or that modifies the provision of the Constitution does in fact create legal uncertainty and can be considered a usurpation of the functions of the legislature?
Yes, we can say that, but I would love to explain it in this manner. The judiciary is an arm of government that is legally recognized, constitutionally provided for. The selection and the appointment of the judiciary, each and every process is provided for in the Constitution. For instance, I will give that of Nigeria Constitution as an example. Section 4 provides for the legislature to make laws. Section 6 provides for the court and the courts within the Nigerian system. So if the judiciary are making laws, they are not actually indirectly making laws. What they are doing is interpretation of laws. When Section 162 of the 1999 Constitution of Nigeria was taken to the Supreme Court, from the Federal High Court to the Appeal Court, then to the Supreme Court, about local government autonomy case, which is the revenue, how local governments are to be administered, their election, is it to be 3 years or 4 years like that of governorship, presidential. Each issues was actually examined, legally examined before each judges of the Supreme Court, justices of the Supreme Court. And then we are able to actually have a landmark decision which in the case of the Attorney General of the Federation and that of the 36 states. That was an interpretation of the Constitution. In interpreting the Constitution, there can be amendments. But when we now look at what amendments are being made, what changes were made through this interpretation, through this judgment by the judiciary, if it still follows the societal needs and in fact it is legally accepted, Section 1, subsection 3 of the Nigerian Constitution provides for any law that is made that goes against that of the provisions of the Constitution is totally invalid. For when a judge, or the judiciary now as an arm of government, as a body itself, when interpretation of court cases are made, as so long as it goes alongside the societal realities and it's legal, we can say that it is still democratic.
Okay, so judges do in fact performing their constitutional functions and are helping the people and helping the states match the international realities of the law. Yes?
Yes. I would love to add that the doctrine of polarity itself, when we are talking about constitutionality, the doctrine of polarity says that when an arm of government can in fact perform another function of another arm of government indirectly. For instance, legislative oversight happens whenever the judiciary are actually reviewing the actions of the legislatures. They are reviewing court cases, they are reviewing budgets that have been passed, among many other things. So there are certain instances whereby the executive are performing their function, but they might also be performing indirectly a function of the legislature. That's where the doctrine of polarity comes in. But all in all, everything is to ensure proper checks and balances, separation of power, and most importantly, democratic principles within the state. Thank you.
It's actually very fantastic that you've mentioned that. So can I infer that as long as a constitution is valid when it provides for checks and balances and separation of governmental powers, yes?
Yes, because that provides for democracy itself.
So is that a compulsory feature of a constitution? Must a constitution limit governmental powers to be valid?
A constitution derives its power from its legality, its binding force, from that of the acceptance and legitimacy from government and from the people. So the persons within the society are given their powers, they are given their rights to the constitution, giving it to the government itself to exercise it on their own behalf. So to prevent arbitrary use of power, authoritarianism, among many other evil vices within the society, a constitution actually has to limit the power. It gives it, it provides for it, but it also limits it.
Thank you so much. So for our final question on living constitution, Ms. Itohan, do you believe that the concept of a living constitution can be sufficient in this modern day time to track technological changes? Nowadays, we see different things such as AI, such as deep fakes, such as so many deep technological advancements that could in fact affect the core of a country. So do you believe that the concept of a living constitution can actually ensure that the constitution is equipped for those to govern those technological advancements?
Okay, thank you for that question. Yes, the setup or the concept of a living constitution is such that it's actually able to be fast-paced and follow the changes in society, and particularly to technological shifts and advances. It would be well equipped to do that. However, it would not just the constitution itself would not bear the entire brunt of that, because you have, ancillary legislations, acts and statutes that actually cater to these things in particular. You have, your Data Privacy Act, you have, AI acts and laws that specifically cater to these things. So, of course, the Constitution would serve as the foundational document such that any other law that is being made should not derogate from its principles. But primarily, the Constitution itself would not bear the brunt of that rapid change, especially when it comes to something like technology. There's always something new evolving. That could lead to a lot of legal uncertainty if the Constitution is just changing all the time. So the Constitution would not bear the brunt of that change. It would mostly be the ancillary statutes and legislations that cater to those things.
The concept of living constitution would be sufficient to enable the Constitution to empower the arms of government to match those technological advancements through laws.
Yes.
Thank you very much. So that brings us to the conclusion of the part of this panel session on the living constitution. So we will now move on to eternity clauses within the Constitution itself. Can both panelists let us know what they understand by an eternity clause within the Constitution? Mr. Awofadeju?
Thank you for the question. My understanding of the phrase eternity clause itself refers to a provision within the Constitution that cannot be amended, that cannot be altered, that cannot be changed or removed. That is in its simple definition. Eternity clauses refers to sections within the Constitution, provisions within the Constitution that cannot at any point in time be changed. Why? Because they have been embedded, they have been seen and actually enacted to be unchangeable, unamendable. An example would be Section 174 of Thailand Constitution that provides for their monarchical system and also their religion, which is Islam. So there's no change that can occur. There's no amendment that can actually happen in this instance. Another will also be Article 79, paragraph 3 of Germany Constitution that provides for their own democratic system, whereby they are unable to change it and on no circumstance can it be amended. That is what eternity clauses provide for. Eternity clauses provides for sections within the Constitution that can't be changed and cannot be altered. Hence, they might. Thank you.
Thank you, Mr. Arabi. Ms. Itohan, can you also give us your definition of an eternity clause?
Okay, thank you. So very much in line in what Mr. Alabi has shared. An eternity clause is a clause or a provision in a constitution that is basically immune from change or from amendment. It exists in perpetuity. No matter what happens, it cannot be changed. It is immutable, set in stone. It is frozen in time. So that's what an eternity clause is in simple terms.
Okay, so like you said, an eternity clause is frozen in time. So what if the eternity clause no longer represents the identity or the reality of the people? In that circumstance, can the eternity clause then be considered unconstitutional?
Yes, it can be. It can be considered not unconstitutional, but maybe undemocratic, right? That is the main argument against, eternity clauses, that they are undemocratic, right? And they, in a sense, they take away from the right of the people to have their popular opinion or their interests at the time being reflected in the Constitution. So it is not unconstitutional, but it is, undemocratic.
Okay, so in that instance, can you actually, looking at the positive sides of an eternity clause, can you say that, considering the fact that in the future there's a possibility that the majority or the new identity of the people can actually go against certain fundamental human rights or against democracy itself, can you say that an eternity clause would then be a necessary defense against that new identity?
Could you come again with that question?
Of course. So looking at the positive side of eternity clauses, in the same way that an eternity clause to some extent can be undemocratic, if in the future, years after the eternity clause has been created, the new identity of the people now goes against fundamental human rights or goes against democracy itself, do you believe eternity clauses can be an actual protection for the former or the original intention of the Constitution?
Okay. Think you understand now. So yeah, one of the arguments for eternity clauses is that they are mostly used. I think there was a statistic that said out of the maybe 80 something or something countries that do have eternity clauses in their constitutions, a majority of those clauses preserve very core principles, very human rights related principles, and not necessarily things that should change in a couple of years' time. So in like 20 years, you should still have your rights to life. You should still have your rights to your property movement, etc., etc. So it is one of the arguments for eternity clauses in that they do preserve the core principles and core values. So they do protect, they can protect from even an anarchy. So in a situation where maybe there's an uprising or something, you can still any government or any person who takes over, that government should never be able to constitutionally derogate from your fundamental human rights, because that provision has been entrenched and it cannot be amended under any circumstance. So on the flip side, or on the other side of the spectrum, yes, it does serve some function in protecting core principles and values.
So I think my biggest takeaway from this is that the eternity clauses have so many pros and cons that you can't actually be completely against it, but you also can't be completely for it. Great, so absolutely. Now I think my next question to Mr. Wofadeju is on the actual effectiveness of eternity clauses. So previously we discussed military governments and how when they come into power, they tend to freeze certain parts of the Constitution. So do you believe in that kind of circumstance that an eternity clause would actually protect democracy? Or do you believe that it's very possible that it could so easily be frozen and ignored, therefore being ineffective? My apologies, Mr. Wofadeju, we cannot hear you.
Hello, can you hear me?
Yes, we can.
All right, so I would love to start with this quote, which is power resides where people believe it is. So where persons believe that this is what we are going to follow. In the case whereby a military government comes into power, yes, the first thing they will do is to suspend the constitution itself. That is a major action that they will exercise that will make sure that whatever they are doing cannot be probably fought against, or they cannot be taken to court against for. So they will suspend the constitution itself and declare the constitution not in existence in the country. But eternity clause will ensure, after it has been entrenched in the citizen's mind, that there is no provision for military system of government. There is no provision for any undemocratic system of government. So if persons within the society know that this military system that government that actually came to take over power through a coup d'etat are undemocratic and they are not accepted by us, definitely the eternity clause is actually taking its function and is telling the military government itself that they are undemocratic and they are not actually accepted by persons within the society.
Okay. So basically, the validity of eternity clauses still depends on the general identity and will of the people. Yes?
Yes, it does.
Thank you very much, Mr. Wofadeju. So this will bring us to the end of our questioning on eternity clauses, and we will move on to the final part of this session on the kinds of constitution. So we are, or at least I'm aware, that we have written and unwritten constitutions, we have parliamentary and presidential constitution, federal and unitary constitution. So I would like to discuss each of these different kinds, starting with written constitutions. Do you believe that written constitutions are more effective than unwritten constitutions in preventing conflicts in exercise of governmental powers? And this question goes to Ms. Itohan.
Thank you for the question. So yes, a written constitution generally provides for more stability, more certainty, especially because, written constitutions are subject to, judicial review. And in written constitutions, you see a lot of provisions as to the limiting of powers, the limiting of government, the separation of powers, judicial independence, checks and balances, things that generally make for stability in a state, right, are provided for in a written constitution. And one of the, okay, let's not go there yet. So those things are generally provided for in a written constitution, as opposed to an uncodified constitution, which doesn't usually make for a lot of certainty or stability as to what the law is, because for instance, in the UK, that practices a parliamentary sovereignty where there is no single codified constitution, it is fast-paced for sure, and also because the parliament is democratically elected, that is good. But in the sense of providing for stability, I would say that a written constitution definitely is set up more to provide that for a state.
Thank you so much, Ms. Itohan. If we can also get an answer from Mr. Awofadeju on that question.
Okay, can you come again on the question itself? Because I wasn't able to follow through. I had issues.
Of course. The question is, do you believe written constitutions are more effective than unwritten constitutions in ensuring that there are less conflicts or no conflicts in the exercise of governmental powers?
In ensuring that there are little or no conflict in the exercise of governmental powers, there has to be clear definition. There has to be clear provisions. That is, this section of the Constitution provides for it. A written constitution is mostly unambiguous. That is, it is written, clearly stated within the Constitution. There are sections of the Constitution that provides for this. But when we move to unwritten constitution, it more or less might not be ambiguous, but its interpretation might be ambiguous because it will be susceptible to different forms of interpretation. It will be susceptible to different forms of person saying, this is what the Constitution provides for. This is what my own custom, my own convention, this is what this judicial precedent actually means. So a written constitution actually provides for and ensure better clarification, better clarity, interpretation, and division of powers among the different organs of government. The legislature are well aware that in the instance of Nigerian constitution and Nigerian system, legal system, and state, the legislature are aware of the fact that the section 4 of the Nigerian constitution provides for their powers. Chapter 5 of the Nigerian Constitution provides for everything that relates to legislature in Nigeria, from the federal system, which is from the federal level, which is provides for the National Assembly, down to the state level, the House of Assembly, bicameralism, unicameralism. The judiciary are well aware of the fact that Chapter 7 of the Nigerian Constitution gives the Supreme Court the highest decision. Whatever decision the Supreme Court makes is what is final and binding on each and every person within a state, within the Nigerian state. So written constitution removes ambiguity in clarity, in interpretation of the constitution. So it provides for easy understanding of the constitution, easy reference to the constitution. And that's the reason why I'm able to, I as an intern, as like Lata, I'm able to refer to section 4, section 5, section 6, chapters within the Nigerian constitution easily. But when it relates to the United Kingdom, I have to go in depth to judicial cases like like Lord Church EU, among many others, so for me to be able to understand the conventions, the customs of Britain itself. So it is not straightforward, and it might be ambiguous for interpretation and clarity. Thank you.
So a written constitution is more easily findable, if I might understand you correctly, because even laymen can be able to spot out the laws and can be able to see exactly what the functions of their governments are. Yes?
Yes, ma'am.
Fantastic. Now let's discuss parliamentary versus presidential constitutions. So and this question is directed to both the interns, which constitution do you think it's better? And do you believe that because a parliament is a more recent representation of the people's choices, that it is more democratic?
Well, from my perspective, I am well aware of the fact that both parliament constitution and presidential constitution have their pros and cons. For instance, parliament constitution itself, part of its advantage is that it is easily amended. The legislature, there is parliamentary supremacy. That is, the parliament decide what the law is itself. The parliament decides that this is what is right for the person based on the people that they are representing and changing societal values, changing society economic frameworks, amongst others. So, but another disadvantage of it is part of what I said earlier, that its its constitution is not actually, it is not written. It is mostly unwritten. It is not contained in a single codified document. Hence, it might lead to ambiguous interpretation, applications, and even understanding among persons within the society. But when we go to a presidential system of government, it is easily going to be easily referenced among persons within the society. Even an 80 years old woman that is selling markets and that is selling foodstuffs in a market will be able to know that Chapter 4 of the Nigerian Constitution provides for our own fundamental rights. Section 33 provides for our right to life. That is, our life cannot be arbitrarily taken without what express acceptance by the Constitution. Hence, we are able to see that presidential system, despite the fact that it is rigid, its amendment procedures is very, very rigid. When the amendment procedures for the Nigerian Constitution can be seen under the legislature itself, Section 9, whereby you have to have two-third majority, simple majority, certain numbers of persons in attendance in the legislative house. So both systems, both constitutions have their pros and cons, their disadvantages and advantages. So if placed on a scale, I would personally be going for presidential system of government, because despite the fact that presidential system of government, presidential constitution itself cannot be easily amended, but it can be amended. And if taken through due process, it can be amended and it will not be easily manipulated for majority wants and then thereby sidelining minority rights itself. Thank you.
So, Ms. Itohan, I actually have a different question for you that's still related to this particular question. So it appears from Mr. Wofadeju's explanation that he prefers presidential constitutions because the parliamentary system is harder to find and can technically be considered a bit weaker because it's a bit more confusing. So do you think that in a non-Western political context, for example, in Africa, in Asia, where we more often have, military government takeovers, we more often have dictatorships occurring, do you think that a parliamentary system would serve us better because of the fact that, we are consistently updating our laws, we are consistently updating our understanding of, what is considered proper in an international context? So do you think that a parliamentary system would serve us better because of the continuous changes in our government and in our legal systems?
Okay. Thank you so much for your question. Okay, so I think to go back to the foundation or to the basics, a presidential system is one that, the executive powers are fused in one person. He's both the president is both the head of state and the head of government. And typically in a presidential system, that is what makes for, separation of powers between the legislature, the judiciary and the executive, right? But when you have a parliamentary government, you have the prime minister, who is different from he is not the head of state, I believe. But he performs both executive and legislative functions. So I imagine that if we were to pivot, if non-Western nations were to pivot to a parliamentary style of government or a parliamentary constitution, I don't think that would actually aid us, because in the event that a military coup were to happen, that means both executive and legislative powers would be vested in that military president, meaning that he would then be able to make laws suiting that military regime to the detriment of the people. But with a presidential system where there's that clear separation between the executive arm and the legislative arm, you still are able to depend on what the law says to protect you, right? To protect you from whatever the military government might try to do. So I do not think that a parliamentary system would really serve to protect. Depending on the angle that you look at it, maybe it might serve to make lawmaking a bit more fast-paced, but in the event of a military uprising or coup, I do not think that would serve the state. I'm so sorry, your mic is muted, ma'am.
Yes, of course. It appears we have a question, and it says that in my apologies. My apologies. Could the person who sent the question in the chat box resend it? Seems to have disappeared from my chat box. But just for context, I think I would like you to rephrase your question, Miss Itohan. Okay.
My question?
My apologies. The question is, but in a military government, executive and legislative powers are vested in the military head of state. So regardless of whether it's a parliamentary or a presidential system of government, both powers would still be vested in the military head of state. So what do you have to say? Does that affect your answer on whether parliamentary or presidential constitutions are preferable? And so just before you answer, I believe there was a bit of a confusion. So in a parliamentary system of government, the head of state and the head of government are different because the head of government is the prime minister, but the head of state is usually the monarchical lead. But in the presidential system of government, the head of state and head of government are the same because they are vested in the president and the president alone. So just with that bit of clarity and with that question, does that affect your answer?
Okay, my apologies. Did I say something different from that? Because I believe that I said that in a presidential system, those powers are vested in just the president. But in a parliamentary system, the prime minister is not the head of state. I
believe you mixed them up a bit, but that's fine. You can.
Oh, okay, my apologies. So yes, to the question that was stated, yes, in light of that, it does. I would approach the question from a different angle because, like I said, the question can be approached from depending on how you view it. In that case, yes, a parliamentary system could be more beneficial because in a parliamentary system of government, there isn't really a fixed tenure for who the prime minister is. There's what you might call an instability in the sense that he can be ousted. The prime minister can be ousted when he doesn't have the popular vote anymore. But again, in the context of a military regime, the military governor doesn't care about your popular vote. But in the case that he were to care, then a parliamentary system would definitely serve in that regard. I don't know if that answers.
It does. Thank you so much for the clarity. So I have one more question on federal and unitary systems of government and the constitutions within those kind of governments. So what are the differences in the constitutional amendments in a federal state and a unitary state? Are there any difference in constitutional amendments in a federal state and a unitary state? If both the panelists could answer. Go on, Ms. Itohan. Answer the question.
So to answer the question, okay.
You can both answer anyone. That's fine.
All right. To answer the question, the amendment procedure in the unitary system of government versus that of the federal system of government differs entirely. Unitary system of government is an administration of governance whereby every power within the state is concentrated in a single central authority. So in that system of government, we have every power that of amendment, that of judiciary, legislature, executive. Each one of them is concentrated in one single central authority. Hence, it allows for flexibility. For instance, let's look at the ideology of a military system of government. A military system of government can, in the history of Nigeria, a military head has made over 62 laws within 3 months, the space of 3 months a year. Why? How is this possible? Because there's no arm of government to actually review it. There's no arm of government to say that we are going through different stages, the 5 stages of bill before it is passed into law, amended, among many others. So there is ease to it, to making laws, to reviewing laws, and even to what, to judicial interpretation of those laws. But when we come to a federal system of government, which aligns most of the times with presidential system of government, we're able to see that powers are constitutionally divided between the central government and constituent units within the state. Taking the instance of Nigerian state, we have the federal government, we have the state government, we have the local government. Hence, amendment procedures are not really easy. It is rigid because if there is to be a creation of a new state within the Nigerian country now, I mean, the question of such a state is literally not really visible because it has to go through each House of Assembly in the 36 states and also go through the House of Representatives, the Senate. So the creation of state amendment procedures for the federal system of government is not really easy, but it can be achieved. But for the unitary system of government, it is most easy, very, very easy, as it is flexible. It allows for easy decision making. Powers are already concentrated in a single central authority. Thank you.
Sorry,
Yes,
Miss.
ma. You seem to be muted.
Thank you. Mrs. Johan, you can also answer the question on whether there's any difference in the procedures of constitutional amendment in a federal or a unitary state.
Okay, so yes, just in line with what Mr. Alabi has shared, in a unitary system of government, amendment tends to be quicker because it is not passing through all the red tape and bureaucracy that you would typically see in a federal system of government, right? Where power is decentralized. There's power in the federal government, the state government, and the local government, right? And you have different legislative bodies. Have the House of, in Nigeria, using Nigeria as an example, you have the House of Assembly, the House of Senate. So there's so much process and red tape that law amendment has to go through. I think you even have to get the president's assent at a particular point, right? Because he has veto power. So all that exists in a federal system of government, but in a unitary system, power is vested in just one single governing body that makes for, the policies and the amendments and all of that. So when it comes to amendment, it is very stress-free. It's very fast because the decision is just being made between the people who make up that single governing body.
Thank you so much.
Yes, ma. If I can add to it, ma, I would love to make mention of the newly electoral act that ought to have been passed by the current Senate and the current National Assembly of Nigeria. But in reality, this law has not been passed because we had to wait 26 to 27 days for them to resume plenary sittings before the electoral act is now even being presented or being examined by the National Assembly. So we are able to say that if it was in a unitary system of government, such a law and act would have been passed into law already without even waiting for the approval or for the review or for the legislative oversight over such a bill. So that is what I want to add. Thank you.
Thank you so much, Ms. Itohan and Mr. Awofadeju. I think with all the explanations that have been given, I'm starting to see a clear link between written, presidential, and federal systems of constitutions, and the same between unwritten, parliamentary, and unitary systems of. So that brings us to our questions on the kinds of constitutions that we have, and we are gradually getting to the end of our panel session. If any of the audience have any more questions, please feel free to put them in the chat box or to raise up your hand after we ask the last question. So I now have one final question for both the panelists. We will start with Ms. Itohan and then go to Mr. Awofodeju. So I would like to ask, what is your biggest takeaway from your study of the concept of the Constitution thus far?
Okay, thank you for that question. My biggest takeaway in the study of the concept of the Constitution, I think it would be the first thing that we learned, or I learned, doing just that preliminary studies and research on it, is that the Constitution is so nuanced. Like Mr. Alabi shared in the very beginning, where he said there is no single definition of what a constitution is. So you go from jurisdiction to jurisdiction. The Constitution, or the idea of it, is shifting or changing. So it's not one, fixed definition. It's not a one size fits all, is what I would say. So when you look at a country like China that even has a written constitution, but China does not adhere to, constitutional supremacy, which is what you would typically think when you have a written constitution. China just has its constitution as a guide for how, power should be, for how power should be demonstrated or how it should be applied. But the constitution is not binding the way it is usually in a written constitution. So when you go from jurisdiction or country to country, state to state, it's very interesting to see their interpretation or their take, or even how the constitution works for them, because we can have so many discussions about, is a parliamentary system better? Is a parliamentary sovereignty better? Is a constitutional supremacy better? And there's arguments for and against. And I mean, personally, I would tilt to a constitutional supremacy. But you look at the UK that has been in existence for so long, and they have an uncodified constitution, and it is working out so well for them. They have, there's more of a democracy over there than there is. There's more of, your rights being protected in a country like that, as opposed to thinking about Nigeria, unfortunately, where you have a written constitution, but there's still so much derogation from your fundamental human rights, and with little to no recourse to justice. So I think my biggest takeaway is just, analyzing and seeing how different kinds of constitutions actually work for different nations, and it's still working out for everybody. And also, sorry, I also did enjoy, considering eternity clauses. The time when we started this, I didn't even have an idea what the eternity clauses were a thing, right? So I enjoyed, learning, the originalism versus a living constitution. All of those things, I think, really make for a well-rounded lawyer or policymaker, any of those things that you want to be.
Thank you so much, Ms. Itohan. I think we have also all gained a lot from you here today. And I think my biggest takeaway from your takeaway is that a constitution is such a diverse, comprehensive concept that we should never presume any limitations to its definition, because it can be so many things. So thank you so much for that. I want to ask Mr. Awofodeju for his own biggest takeaway from the study of the Constitution.
From my study of the Constitution, my biggest takeaway can be tilted towards that of eternity clauses. Examining eternity clause, I'm actually able to have an expansive knowledge that there are certain sections of the Constitution, certain provisions of the Constitution that cannot be amended. So there are certain provisions of the Constitution that they have to be there. There's no limitation, there's no changes to them. And I'm also actually able to say that if the current societal values, if there is a revolution in the society, if persons feel that their rights are not actually being protected, if they feel that this provision of the Constitution that itself cannot be changed is not giving us the best of what we want from this system, whether it is democratic, whether it is parliamentary, whether it is federal unitary system of government, it is not giving us the best. I believe that such eternity clauses, or even the entire Constitution itself, can be revisited, changed, not even talking about amended now. That is something that I've been able to learn from the concept of what a constitution is, including that of judicial activism. The fact is, judiciary do not make the law directly, but they are still empowered legally to interpret the law, bringing me to that examination of doctrine of polarity itself.
Then I was even able to look at doctrine of judicial restraint, whereby, thank you so much. I've been able to learn a lot.
I'm so sorry. If I could add one more thing as well. Because when he mentioned eternity clauses, I realized that there was even something that we didn't get to mention, which is that, okay, another big takeaway for me is how law is very nuanced. The concept of a constitution is very nuanced, especially, when we're speaking about eternity clauses, those are, constitutional interpretation, constitutional amendment, arguments, and they're very nuanced, it's a very nuanced conversation. And when we talk about eternity clauses, yes, there are pros and there are cons, but the cons might outweigh the pros, and so a suggested alternative to an eternity clause would be entrenchment, right? Entrenching provisions is very different from making them totally immutable from change. It just makes changing it a very rigorous process. And in the process of, trying to amend that, in the process of how rigorous it is, one might find that, oh, actually, maybe we shouldn't touch this thing, or maybe we should press on and actually touch this thing. So yeah, that's another takeaway for me.
Thank you so much. I think we've learned so many things from you both. We've learned about the doctrine of polarity, and now we just learned about the doctrine of entrenchment. So thank you so much. This has been such an amazing panel session. I hope all our attendees have gained so much. I hope you are invigorated to learn more about the Constitution, to do personal research, and perhaps to apply for an internship at the Lex Lata Center, because you can see that interns are so brilliant and that they've gained so much. Before we conclude, I would like to ask if there are any questions from the audience whatsoever. Feel free to put in the chat box or to raise up your virtual hand, and we will get right to your question. As you can see, our panelists are very, very enlightened on the subject. I'm sure any question you give, they are more than able to answer it. So are there any questions from the audience? It appears there are none. So I want to give a very big thank you to our panelists. Ms. Ito all spent here, and we have been very well educated. Thank you very much.
Thank you so much as well. Thank you for your time.
Thank you so much. I wish you the best of luck with the rest of your internship. I would also like to thank the Lex Lata Center for this platform and for the opportunity provided to all the students and professionals that might be here that have come here to learn about the Constitution. We are very welcome. We are very grateful. And we especially like to thank the Executive Director, Dr. Wole Kuniji, for continually providing these opportunities to the members of the center. This will now bring us to the conclusion of our panel session today on the concept of a constitution. I hope everyone has gained a lot, and we will see you in our next panel session tomorrow on international law. Have a great day, everyone. Goodbye.